Lovely. Okay. Well, as Caitlin said, my name's Caroline Barker. I'm one of the legal directors in the regulatory healthcare team at HCR Law. I've been doing this a number of years, dealing with CQC and its predecessors. And unfortunately, they are a beast that you cannot avoid if you want to be regulated by them. So today I'm going to be talking about where we are with CQC at the minute in terms of their change process, and then also looking at their inspection regime and what sort of types or the types of enforcement that they can take against you as providers. Now, I work, as I say, in the regulatory healthcare team, but HCR also offers a whole range of different types of support to health and social care providers, whether that's corporate deals, real estate and employment. So if there is anything that you do need wider than the issues that are raised today, then obviously please do get in contact, and I can pop you in contact with one of my colleagues. So CQC, oh, don't you just love them? Yes, they've had some very long-standing and ongoing issues ever since really they tried to introduce the single assessment framework, and it has been hugely criticised. We've had the Penny Dash report, we've had the Sir Mike Richards report, both of which basically said it wasn't fit for purpose. We've had quite a few personnel changes with the senior board leaving, and really it became apparent fairly quickly that there was just simply a lack of transparency around the single assessment framework regarding scoring, judgments, and the way that inspection reports were presented. We've also had some fun around the regulatory platform and the provider portal. And ongoing, I'm sure some of you will have had some ongoing issues with the provider portal. I had a client the other week who was trying to upload fact accuracy comments to the portal, and because of the delays on it, it took her 8 hours to do. So, you know, CQC have recognised that it's not fit for purpose, and we are slowly getting somewhere with introducing changes. I'm sure you're aware that they did introduce, or they issued a consultation paper towards the end of last year, which closed in December, looking at how they were going to change the current scoring model, how they were going to make judgments, and simplifying its rating process. It does seem a little bit ironic to me that we're basically moving back to what the system that it appears we're moving back to the system that we had previously. And I'm sure for those of you who've been in the industry for a long time, you know that every few years CQC sort of reinvents the wheel in terms of its scoring process and its presentation process. And it's not always particularly clear why they do that. But as we know, that the single assessment framework has been deemed not fit for purpose, and they are looking to roll out a new regime. But they have said that it's going to be towards the end of this year. So I'm sorry to say that it's going to be a little while longer before we understand exactly what is going to be involved and what it's going to look like. So why does compliance matter? Seems a bit of a silly question to ask, but I think it's an important one. Obviously, one of the purposes of the talk today is to talk around CQC and the type of action that it can take against providers, but also compliance matters that relate to CQC can have a knock-on effect with the local authority through safeguardings or contractual matters. The health and safety executive can be involved, the police can get involved if there's a potential criminal activity, and also the coroner can become involved where there's been a death in the home that is perhaps unexplained. We always would like people to be proactive with their compliance rather than reactive, because it does cost time and it does cost money to put things right. Can become quite resource intensive, both in terms of your time and cost. And there can be significant reputational damage to providers and sometimes individuals as well. So where are we at the moment with the changes that CQC are making? Well, I think it's really important to emphasise that the regulations haven't changed. No matter what the systems CQC are putting in place around the ratings and the judgments, at the core of it, the regulations that you have to comply with have not changed. And they are the things that you should be looking at in order to make sure that you are compliant. CQC, really since COVID, has moved to a risk-based approach. So most inspections are being carried out on the basis of information of concern. We know that there have been issues raised by the sector around aged ratings. People have been stuck with historic ratings. That has now eventually been recognised by CQC. I was on a webinar with CQC last year towards the end, and Chris Badger did say, they recognised that aged ratings were a risk and they wanted to try and rebalance that. But at the moment, what we are seeing at HCR Law is inspection reports and enforcement action being taken on the basis that they have concerns at a service. So hopefully that will change in due course, where people are actually able to have more regular inspections can start to happen again, but that's very much reliant on CQC getting their house in order and having the resources to do it. So what happens if you do get inspected? Now, I'm sure it's a situation that you're familiar with. CQC can inspect or assess at any point. I've separated out inspection and assessment because inspection is technically them crossing the threshold to come and actually review the service. But we are finding that sometimes they are doing these assessments remotely. And one of the things that we are seeing that has changed since systems previously is that they can be carrying these out over a number of days or weeks. So they may come in and do a physical inspection, then actually carry on the assessment remotely, asking for further information. If CQC does come to your service, then get involved. Don't just let them sit in a room looking at paperwork. Go in, make sure that you're being as helpful as possible by offering assistance, asking to provide them with documents, asking them if there are any concerns, is there anything that they need clarified, and providing documentation where appropriate. If you think there is something that they haven't asked for, which is important, then provide that too. And importantly, take notes of what you have shown them, what the discussions you have had, because this will stand you in very good stead should you need to challenge anything at a later date. Now, CQC is supposed to give feedback. I have heard mixed messages from providers about whether they are actually consistently doing this. Sometimes they are doing it verbally, sometimes they are just providing written feedback. But again, if you do have feedback sessions, take notes. And we always recommend that providers should have a dedicated note taker whose job it is just to take the notes, because it can be very difficult when you're trying to hold a conversation with somebody to take accurate notes at the same time. Now, at that feedback session, if it takes place, then if there are things that CQC are saying that you don't agree with, then there is an opportunity there to challenge, to present further information and to give them additional evidence. And if there is something that you would say don't agree with and you have evidence, then we always recommend sending it to CQC following that feedback session. Again, we recommend that it's done quickly. Don't leave it several days before sending it. Send it very quickly after the feedback session, because what you are wanting to try to do is change. If you don't agree with something, you're trying to change aspects or CQC's view before it's committed to writing in a draft inspection report. Now, when they do come to issue the draft inspection report, that report will set out how you are meeting the regulations or not meeting the regulations. They will determine whether you are in breach of the regulations. And as you know, they will set you ratings for each of the key questions. And CQC have rating limiters. So there are certain instances where you cannot achieve certain ratings overall if you have particular evidence category scores within the inspection report. Now, you can challenge these reports. I think sometimes providers feel reluctant to do so or don't feel that it's worth doing. But one important thing to note is that once that report is published, it becomes the established truth. And we always say to providers, if there is something that you don't agree with, that you don't think is reflective of the service, it is always important to put your case across. Now, even if it doesn't result in a change for any reason, then you have on record that you did challenge and you didn't agree, and that information can be used to help communicate with your commissioners, service users, families, and also should CQC take further action at a later date, they will always rely on your regulatory history and say, we found these issues at this time at previous inspections. And again, you therefore have something to refer back to say, well, we didn't agree with it at the time. When you undertake your factual accuracy comments, it isn't purely factual. You are allowed to challenge the judgments, you are allowed to challenge the proportionality of those judgments, and also the conduct of inspectors, because they are all interlinked. So it is important that you do so when given the opportunity. You have 10 working days to make that challenge, which is a relatively short period of time to gather the evidence that you wish to rely on and actually put together factual accuracy comments. What we have found with the single assessment framework is that the reports are much shorter, and we're finding that they're actually quite vague in places. We're finding that they are using stock phrases. They clearly have a drop-down menu with sentences to add, and then trying to fill in the rest through the specifics of the service. But one thing is that you need to understand what they are referring to. So the first question is to go through the report line by line. Can you identify who or what they're referring to? And if not, ask them. You have the right to respond to this, but of course you cannot challenge factual accuracy. Sorry, get my teeth in. If you don't know what they're referring to. So if you do need to request information and further information, then do that very quickly, because there is no guarantee that CQC will give you any extension to the time frame to provide comments. Now, CQC have also said that they are only required to put in their best evidence into an inspection report. So what we're also finding, which is very frustrating, is that we are making factual accuracy challenges to reports, and then CQC is saying, yes, but we also have this evidence, which didn't get put in the report, but this also backs up what we're saying. Now, if they were to do that, then we would also always say, well, actually, we are required to have a right of response to that information, and that's something that we can help you with should that arise. You are required to submit your factual accuracy comments through the portal. As I mentioned when opening this, very slow and cumbersome. My client spent 8 hours uploading the response and documents. And what you will also find is that CQC have introduced a character limit, which is, again, not very helpful. So for each section, you only have, I think it's 300 characters to respond. You are allowed to append documentation and continue your response on Word documents, but it becomes very fiddly, which is why you need enough time to be able to upload to the portal. Now, once you've submitted your comments, CQC will review them and provide you with a response. Now, sometimes they don't make changes, sometimes they do, but what are the next steps should they not change the report as you would hope? Well, you have the right to make to put in a rating review. Now, this takes place after the report has been published, and you've got to make that rating review within 15 working days of the report being published. However, the only basis upon which you can challenge this rating is on the basis that CQC failed to follow their correct process. It is not an opportunity to say where you disagree with the facts. You can't introduce new evidence. We have found that this is quite a limited appeal, I'll call it appeal process. It's quite a limited, has limited benefits, or we have found that it doesn't work as well as we would hope it would. So I think it's really important that you put in your best and first response when you can during the factual accuracy comment process. There are also other opportunities for you to make complaints about CQC and also potentially judicial review, which can be expensive processes and not want to be taken lightly. But there are other options should CQC not change inspections as they ought to. So that's a very quick run through in terms of inspection process. What I wanted to also talk to you about today was about the enforcement action that CQC can take. Now they have two strands. They can take civil enforcement action against you as well as criminal enforcement. The majority of the rest of this presentation is going to be on the civil enforcement side because that's where we see the biggest action taken by CQC. And again, at HCR, we are seeing particularly around notice of proposals and notice of decisions to cancel registration being the biggest type of action that we're seeing at present. So I thought it would be quite helpful to focus on those today. That's particularly given the fact that CQC are going in looking on the basis of information of concern. They aren't really going in looking for good anymore. So of course, if they've been alerted to there being a problem in a home or a service, they are going in with almost a preconceived idea that they're going to find something. And we are finding that they are taking more serious enforcement action through changing people's registration. However, I'm going to start with a warning notice. That tends to be kind of the low-level enforcement action that CQC can take. Now, some of you may have had these issued before, some of you may not. Now, they're issued where CQC think there's been a breach of regulation or breach of the Health and Social Care Act or conditions of your registration. It can be for a current breach, so they're saying you are currently not doing what you ought to be doing, and they can actually issue them for a past breach, which you have since rectified. Always has seemed a little bit odd to me, but it is possible. They will say, look, we think you are not complying with the regulations. This is what you need to do in order to put it right. And here's a date that you have to comply by. And failure to comply with a warning notice could lead to a prosecution or further civil enforcement action. So again, it's really important to take these things seriously should they land in your inbox. You can actually make representations to these warning notices, and again, you have 10 working days in which to do so. Things that you can challenge in terms of warning notices can be that CQC have made an error, they're factually inaccurate, they shouldn't have been issued, or even if they are accurate, it would be unfair to publish. Again, CQC will consider your evidence and your representations, and they might decide not to uphold your representations, in which case the warning notice will stand. They may uphold your representations, in which case the warning notice is essentially withdrawn, or they might reissue a warning notice. Perhaps they've made an error, they recognise that error and they shouldn't have actually issued it in relation to a particular regulation, but part of it still remains accurate, and they may reissue in relation to the correct regulation. CQC are allowed under legislation to publish the fact that warning notices have been issued, and we have known that they actively let local media outlets know that this is the case. Now, they don't publish the whole warning notice, they'll publish a summary of the notice, but we are aware that local media outlets then contact care homes saying we understand that you've had this warning notice, what do you have to say about it? So again, just be aware that this can be present in the local media, and of course families and service users and commissioners might ask for your input and view on what's happened. Again, you can say where if you've disagreed with it and you've made representations about it, should it be ultimately published, and that's why it's also important to put your side of the story across as well. We sometimes also recommend to clients of actually putting a summary challenge on their website, a summary of their representations on their website, so you can demonstrate to people where you disagree. That's the same for inspection reports as well. Now, moving on to probably the more high-level types of enforcement action, which, as I say, we are seeing more of it at HCR Law. CQC can take quite serious action to restrict your business, and these come in the form of notices of proposals and notices of decisions. Now, if I refer to NOPs and NODs throughout this presentation, that's what I'm referring to. Notices of proposals, NOPs, notices of decisions, NODs. So apologies for that, but I might just slip into the type of language that we use internally. Now, CQC can take action to cancel your registration. They can suspend your registration. They can vary your registration, so they can remove conditions. Now, for some of you, conditions of your registration will be your locations, your homes. So they can actually remove and cancel an individual home registration. They can also impose conditions on your registration, and these could be both positive and negative. So an example of a positive condition might be that you are required to send audits to CQC on a weekly basis. Perhaps they've picked up a particular issue and they want to be assured that something is happening. A negative condition might be that you actually are not allowed to admit any more service users, perhaps without CQC's consent. And they can vary your conditions. So they might say, well, actually, you have to stop providing nursing care if you've got that as a condition of your registration, or you actually have to reduce the number of service users you're allowed to provide services to. They can also refuse your registration should you be submitting a registration application. Now, there are different types of action that CQC can take with varying timescales. They can take action, what we call the slow process, essentially. So they can issue a notice of proposal under Section 26 of the Health and Social Care Act, proceeding to a notice of decision, which ultimately results in an appeal to the first tier tribunal. They can also take action on an urgent basis, where they serve notice of decisions under Section 31 of the Health and Social Care Act, and you essentially skip the proposal stage and then go straight to an appeal to a tribunal. Or, depending on how your registration is set up, if they want to take urgent action where you are a one home provider, so you don't have multiple homes on your registration, they actually have to go to a magistrate's court to take certain action, which again is ultimately appealable to an external tribunal called the first tier tribunal. So I'm going to go through just briefly. I've just mentioned there about how you are set up as a provider might impact how CQC takes action. If you're a single location provider, so you have one location, then CQC have to go to a magistrate's court if they want to take urgent action against you. This was always the case under the Care Standards Act before we moved over to the Health and Social Care Act 2008. But there's appeared to be, or well, a bit of an anomaly has appeared through the Health and Social Care Act 2008 under Section 31 of the Act. So where you are a provider that has multiple locations, as I mentioned earlier, your locations are actually conditions on your registration. And CQC can take action to vary one of those locations. They can do it on an urgent basis, as I say, and that's under Section 31, which means all they have to do is issue a Section 31 notice of decision on you, and it takes effect immediately, which means you are no longer allowed to carry on that activity, the regulated activity, at that particular location. It's a criminal offence for you to continue to do so, and you can appeal it, but ultimately you have to stop the regulated activity at that location immediately, or face potential prosecution for continuing regulated activity unregistered. But I thought, again, let's start with the slow process, which again is the process that we see more of than the urgent processes. And I have just put on screen the first page of a notice of proposal. obviously redacted for confidentiality reasons, but you can, for those of you who've not seen it, and I'm hoping that most of you haven't, you can see the type of document that you will receive. So it is actually headed Notice of Proposal to cancel your registration. They talk about which section of the Health and Social Care Act it's under, and they're saying we're proposing to cancel your registration in respect of your regulated activity. They'll give some registration history and then set out the reasons and the evidence that is relied upon. And evidence can stretch to quite a number of pages depending on the seriousness of the concerns that they have. Now, it's important to note that with a notice of proposal, it is a proposal only. It doesn't take effect immediately, unlike the Section 31 notices and the urgent decisions. And very importantly, you have the right to make representations against this type of action. Now, if you don't make representations, then CQC will move on to the next process, which is issuing a notice of decision. But as we will talk about shortly, that's still not the end of the process. But importantly, you have 28 calendar days to make representations, not working days compared to warning notices and fact accuracy comments, but 28 calendar days to make your representations. Now, what we would do to work with a provider who is subject to a notice of proposal is we would work with you to understand and address each allegation. We work through it line by line, and we will say, do we agree with the allegation? If so, what have we done to put it right? If we don't agree with it, what is the evidence to say it's wrong? And the reason that I mention, what have we done to put things right, if indeed we agree with it, is because the CQC is supposed to consider the current position of the home when it ultimately considers your representations. Therefore, it's really important that you set it out along with evidence. Evidence is key. It's much weaker to put in representations just saying you're doing something without actually something to back that up. So it's really important that you put together and gather evidence that supports what you're saying. And it's important to demonstrate that you're complying with the regulations. As I said at the beginning of this presentation, the regulations have not changed. That is what they are judging you against. So we have to take steps to demonstrate that you are actually complying with the regulations. Before CQC issue the next stage, which is a notice of decision, they don't have to re-inspect before they move to the next stage. Of course, we would always like them to, but I think sometimes they just move to the notice of decision stage without coming back to re-inspect, which can again be frustrating when providers have put a lot of effort into making improvements. But it's just something to be aware of, that it doesn't necessarily mean that they will come back to re-inspect. But what they will do is they will consider your representations along with the evidence, and then they will issue what is known as a notice of decision, a NOD. Now, CQC currently say that they will consider those representations within about 60 working days, but I have known them to be much, much shorter and much, much longer. So as with all things with CQC, we don't really know what we're getting until it again lands in our inbox. Now, if they do issue a notice of decision, when they issue the notice of decision, it will either be to adopt the proposal, and again, this is all the technical language that is used, but they will either adopt the proposal, so they're saying we don't agree with your representations, and we think this is the right process to follow to continue with taking this action against you, or they will not adopt the proposal, in which case they have accepted your representations, and if the proposal is not adopted, then that's the end of the proceedings. That comes to an end, and we'll go back to business as usual. If, however, they do adopt the proposal, that is not the end of the proceedings, and the action that they're proposing still does not take effect. You actually have a further 28 calendar days to appeal to, I've already mentioned, the First Tier Care Standards Tribunal. And this is an independent tribunal to CQC. It sits externally to CQC, and they will ultimately decide the outcome of the case. It is important to just be aware of the fact that this is the 28 calendar days is a statutory deadline. You cannot extend that. You have to get your appeal in by the 28th day. because if you don't, then the proposed action will take effect. So again, really important that you act promptly to deal with these things, and just also be aware around service. I've had situations in the past where clients have perhaps not checked an email address that they have actually given CQC the authority to send things to, and there's been a delay in actually accessing the notice of decision. So really important that if you do receive this document that you do lodge an appeal. So as I say, you've got 28 calendar days to lodge an appeal to the tribunal. You will have to set out the reasons why you think that the CQC's proposed action shouldn't take effect. Also providing evidence and the desired outcomes. CQC then have 20 working days to respond. They will either continue to oppose the appeal or not oppose the appeal, in which case, again, we come to a conclusion on that. But if they do continue to oppose the appeal, then we essentially enter into court proceedings. And we have what is known as a telephone case management hearing, where the legal parties come together with the judge, who will lay down directions. So this is setting out dates to exchange evidence and witness statements, and ultimately set a hearing date. The tribunal itself is actually made up of a judge and 2 specialist panel members, and if you get to a full hearing, and I'll touch on why you may not get to a full hearing shortly, witnesses will be called and asked to give evidence, and the panel members will ask questions of the witnesses. You will be asked questions by the CQC legal representative, and your legal representation, or whoever you may instruct, can also ask questions of witnesses. The tribunal will consider that evidence, and then it will make a decision to either allow the appeal, in which case you've won, or dismiss the appeal, in which case you've lost. And at that point, if you were to lose, then the proposed action will take effect. The tribunal has quite a lot of broad discretion, so it can actually impose its own conditions. So if it thinks that actually this is not quite a straightforward win or lose, they could perhaps issue conditions on your registration as well. Now, I mentioned briefly when we were talking about the proposal stage that CQC are supposed to consider the current position of the location or home at the time it makes its decision to issue the notice of decision, but that is also true of the first tier tribunal. What they are looking at is, are you currently complying with the regulations? So again, this is why it's so important to provide evidence about what you're doing to meet the regulations. That is not to say that the history is not relevant. If you are a provider who has essentially gone in and out of compliance over a period of time, have you just scraped by into compliance? That will be taken into consideration. So which is why it's really important to work on improvements and embedding changes that you make over the course of the period of time that you have from the notice of proposal being issued to a final tribunal hearing. And just make the point that this is different to the factor accuracy comment process, because you can include improvements since inspection, whereas with factor accuracy comment you can't. It has to be at the date of the inspection. So when CQC issue a notice of proposal, you actually, if it should go to a full tribunal hearing, you're actually talking about 6 to 9 months from start to finish. You actually have quite a long period of time to continue to work on the location or home, particularly if there have been issues. So we are essentially kind of buying time in this process to make improvements. This is not a time to sit back, but as I said, it's important to put into action any changes, continue rolling it out, checking it and embedding it, because that will be important for any final hearing. It is also important to say that CQC can actually withdraw its opposition to the appeal at any point, so it's not guaranteed that you will get to a final appeal hearing. That will also depend on whether they come out to reinspect, what action you're taking as a provider to make improvements that you can demonstrate. But if they then can withdraw at some point, and we then have to enter into something technical called a consent order with the tribunal. But it is possible, but no guarantees that proceedings can end before it gets to a full tribunal hearing. There is a knock-on effect with the notice of proposal and notice of decisions. Now, it is important again to note that CQC cannot publish the fact that they've issued a notice of proposal, but they do share it with commissioners, and which they are entitled to do. What they can't do is say publish to the general public that they've taken this action against you. But what I have seen with CQC doing this is, again, a knock-on effect, because commissioners then get a bit twitchy because they think that the home's going to close down. We've had to intervene and say, no, this is just a proposal. We've actually got a long period of time before anything ultimately will happen. And we've had local authorities telling service users and families that the home's closing down. So it can lead to firefighting on multiple levels, but again, it's important to communicate with commissioners about what action you're taking. And a notice of proposal often follows a poor inspection. So again, be aware if you do get a poor inspection, again, thinking about the importance of challenging anything you don't agree with at the time. So a poor inspection can lead to, say, media interest, or even family members kind of, again, getting twitchy about what's happening and what you're doing about it. The other type of action, which I've talked about or briefly, is the urgent process. So this is under Section 31 of the Health and Social Care Act. And as I say, this is action where the notice of proposal stage is actually bypassed. So no proposal or representation stage is actually issued. This is taken where the Commission has reasonable cause to believe that unless it acts, any person will or may be exposed to the risk of harm. So it's any person. It could be a staff member. It doesn't necessarily have to be a service user. So they can take all the action that we've mentioned already. They can vary, remove, impose conditions. They can suspend registration. They can cancel your registration. And that's where the importance of how you're set up, whether you've got multiple locations or not on your registration, as to whether they can actually remove one of your locations with immediate effect. Obviously, nobody really wants to be in that position. It does mean that service users have to move out immediately. It can be very chaotic, and if you fail to comply and continue providing a regulated activity without being registered, you are committing a criminal offence. So it's obviously very important that action is taken. That's not to say that you can't appeal it, and that's where we go on to the first tier tribunal appeal. So again, you have a full 28 days to make your appeal. What is slightly different to the slow process of notice of proposal stage with the urgent proceedings is the tribunal recognises, and CQC recognises, that this is a action is very limiting and damaging to a provider's business. So there is actually an understanding that a hearing will take place within 10 working days of an appeal being lodged. So it's a very quick turnaround. Sometimes it's longer than that, but it will be happening in a very short period of time. So we are just truncating the 6 to 9 month period down to essentially a couple of weeks. So we still have to exchange evidence, we still have to do witness statements, and ultimately we'll get to a tribunal hearing. So much more pressured situation to be under, but obviously understandable that people want to move quickly, because you could have a location or a home not operating, you could have a restriction on service user admissions, so really impactful action the CQC can take. One thing actually, just before I go on to letters of intent, which I don't think I actually have covered on the presentation, is that if you are a single home registration, which I mentioned earlier, if they want to close you down, CQC actually have to go to a magistrate's court. So slightly different action, but you might be called to go to magistrate's court depending on your how your registration is set up. From experience, albeit that the magistrate is external to CQC, it tends to be a rubber stamping exercise by the magistrate, because they don't want to be the people who are saying that the regulator who is saying that this home ought to close. They don't want to sort of go against that. So in my experience, it tends to be a little bit of a foregone conclusion on that front. But that's not to say that representation shouldn't be made and positions put forward. What I would say, though, is just moving on to letters of intent on this slide, is that these are essentially precursors to the urgent Section 31 action. And these are letters where CQC will write to a provider and say, we are very concerned at something that's happening at your service, and we want an assurance that things are going to be put right in a very short time frame. Now, often they provide very, very short response times, and we've had them less than 24 hours response time previously. And they essentially are saying, if you don't provide us with the assurances we want, we might proceed to the urgent action that we take. So it's really important that you, if you do receive one of these letters, that you do respond within the time frame that's provided, that you provide evidence of to address the issues that they are raising, and put together an action plan. Now, any action plan that is put together, you should set out achievable dates, bearing in mind, though, that it's not going to go down very well with CQC if you say we're going to do this action in 6 weeks' time. They're saying this is urgent. So, of course, it has to be achievable, but think about whether dates can be shortened. And also say who is responsible. The number of times that I see action plans provided by providers who have no one who is essentially accountable for ensuring that these actions are done, it happens frequently. So say who is going to be responsible and actually give someone that accountability, responsibility to ensure that the action is taken. And then do what you say you are going to do. Again, I think sometimes people feel that they've put in a response, they've sort of headed off the action, and you may well have done, but I also know that CQC have come back a few days later to check whether you have done what you've done, and when people haven't, that's when they progress to the next level of action. So by responding thoroughly and appropriately, it can avoid significant enforcement action. Obviously, that's quite extreme action by closing people down urgently, serving a piece of paper on you, and I don't want to put the frighteners on you, but it can and does happen. And they are the types of action that we are seeing more of in terms of cancellation proceedings. But I thought it was also just important to touch base on issuing or varying your conditions to add conditions to your registration, because these can actually be quite significant and time consuming and overwhelming for businesses. So again, it's important to think about challenging these should you receive such a proposal or notice of decision from CQC adding conditions to your registration. So this is an example of a positive condition that I've seen for a provider where CQC have said we want a monthly report to analyse all incidents that have resulted in harm to service users at each registered location in the preceding calendar month, and setting out the action taken or intended to be taken as a result of each incident. Provide a report on how incidents and notifiable events have been reported appropriately to the local authority and CQC. Now, in relation to the client that had this imposed by a notice of proposal, or proposed to be imposed by a notice of proposal, they actually had about 10 locations from memory. So that's actually a huge piece of work for somebody to provide a report on incidents across 10 locations every single month. But one of the important things to remember about conditions is, if you breach a condition of your registration, CQC can prosecute you. So we will always say a condition has to be very clear about what is required of you. So as a very initial analysis of this particular condition, there's no definition of what harm is. There's no definition of notifiable events. There's no definition of local authority. Is it the host safeguarding local authority, or is it all commissioning local authorities? Harm, as I say, is undefined. Yes, there's definitions of harm under the Care Quality Commission registration regulations, but that isn't referred to within this proposal. So again, think about whether it is worth challenging conditions. Not always. Sometimes it's easier to actually just comply, but I think it's important that you consider what the document and you take early legal advice if you do. CQC can also impose negative conditions, and one of the things that we see, you know, the more frequent negative condition that we see is that you must not admit a service user. Sometimes it's ended there, sometimes it says without the written permission of the CQC. Now, we have challenged this for providers in the past because we say, well, okay, what are the mechanism? Who consents? How long will it take for you to make a decision? What information do you require as CQC to determine whether we can admit a service user? Because again, this is almost could be seen as a backdoor closure. You know, if you're not allowed to admit service users without permission and that permission is never granted and service user numbers reduce, are you going to be in a position where the home or the location is no longer viable? And also, what about adding wording such as not to be unreasonably withheld? Because again, that particular condition says we just have to give you permission. It doesn't say we have to, the basis upon which they ought to consider your request to admit a service user. And again, we've known people who have lost out on service users because CQC have taken too long to make those decisions. And we know that in the sector, sometimes we have to move quickly in order to admit service users. So again, it can have a knock-on financial disadvantage to providers should a condition like this be imposed and remain on your registration. And again, in relation to conditions of registration, important to note that they will remain on your registration until such time that you perhaps apply to have them removed. So they don't just disappear after a certain period of time. So again, something to think about: can you live with this condition on your registration for the rest of time? I'm just going to touch very, very briefly on criminal action that CQC can take. They can prosecute for certain offences, and also many offences are also applicable to individuals if they are committed by certain individuals or within the knowledge of within the knowledge of certain individuals. So people who are directors, registered managers, members of governing bodies, or people who are even not necessarily in name filling those positions, but are in practice fulfilling those positions, can also be prosecuted if certain offences are committed with the consent, connivance or neglect, and that's again the technical language of the legislation, which is why it's so important for you to understand and have in place your governance systems to ensure that you are aware of what is happening in your locations and homes. There are ways to, I've put challenge in inverted commas here. This is more about obviously around defence with criminal action. They might invite you to PACE interviews, so Police and Criminal Evidence Act interviews. They may ask you for to provide information or documentation under Section 64 of the Health and Social Care Act, which is where they are actually essentially collecting evidence of potentially used against you. Again, it's a criminal offence not to comply without reasonable excuse, but really important that any request for Section 64, you only provide what is requested and nothing beyond that request. And again, that is something that we can help you with and are experienced in should those requests come. They can issue penalty notices, basically fines, and they can also caution you, although these are things that we don't see so much of at the moment. So what should you do? Well, as I said at the beginning, regulations have not changed. We are likely to see that inspection is going to increase. CQC have said that they want to tackle historical historical ratings. So those of you who have perhaps had a RI rating for a long time, without an inspection for a few years, you may find that you get re-inspected, but I think that's going to take some time for CQC to do. I mean, take an opportunity if you haven't been inspected by CQC, just to ensure that, you know, everything is as it ought to be. Make sure your audit systems are in place, your governance systems in place, that you're putting things right. And, you know, it's much easier for a provider to be on top of things than actually have things raised by CQC at inspection. You're always on the back foot at that point. Don't ignore CQC action. I think sometimes providers are reluctant to upset CQC, but actually it's as well within your right to tell them where they have got things wrong. That's not to say we challenge everything for the sake of challenge, not at all, but if things are factually inaccurate or it doesn't reflect your service or CQC have been disproportionate, then it is important that you get on record that you don't agree. And it is also important that you take action promptly, not to just fire off a response without thought, but what I mean is when you get any sort of paperwork from CQC, that you look at it straight away, you consider it, you review it, you consider whether the right thing to do, what the right action to take is, and again we can help you understand that. And importantly, don't panic. I know I've obviously covered a lot there, and some of it can be quite scary in terms of the action that CQC can take. And it does take a big toll on providers, and it is a stressful situation. But, you know, with a clear strategy in place, and we work with you through the process and explaining the process, as well as helping you with presenting a strong and robust response to any action, you know, things can be done to hopefully change the course of events. So a little bit of a whistle-stop tour of CQC enforcement, but obviously, as Caitlin said, obviously happy to take any questions. I will just stop sharing my screen